welcome. And this is the final session of the series of webinars that we've been holding from August last year, focused on the different aspects of being an external member or an internal member on the internal committee of a company. So this is a session that's been focused on providing some skill sets and providing some general guidance in terms of what are the do's and don'ts when one is a member of the internal committee. At any rate, this is not meant to be legal guidance or anything of that sort. So if there are any specific queries that one has, please do reach out to us or to your advisor on this issue of the prevention of sexual harassment law. All right, before I get started, hi Dibajyoti, welcome. Good to see you here as well. Before we get started, I also wanted to add that quite a few of you have been asking about the free PoSH policy that we had promised we would distribute. So that is something that we will do mostly by the end of next week. We will have that policy out to all of you who have participated in our webinar. So don't worry about it. You'll all get it as long as you have registered for the webinar. You will get a copy of the PoSH policy that we have prepared. It's a very standard generic policy to help in case you don't have a policy in your organization. Then this is something that you can plug and play or use without any difficulty. It covers all the key points and is designed to ensure that your organization is in complete compliance with the PoSH law. All right. So as we have been discussing over the last few months, weeks, this is the last of the series of webinars. Of course, we will have other webinars as we go along, but on the IC essential skills, this is the last one, and this one is focused on the essentials of order writing. So in the recent times, we have seen a lot of instances where orders of the internal committee are either being sent back by higher courts, either the labor tribunal or even a high court. They are sending the orders back because the orders are not properly written, are not following the proper format, or even if a committee has acted appropriately, it has not come out in the way in the order. So a higher court that is reviewing the order sometimes comes to the conclusion that maybe principles of natural justice has not been followed, or any of those things, right? So therefore, it is very, very important that any internal committee, after it's completed all the deliberations and it's completed all the evidence appreciation, all of those things, the entire process is over, then it needs to quietly sit down and figure out how best to capture all the different aspects of the order, all the different aspects of the entire case in a reasoned order. Therefore, this session on the essentials of order writing is very, very critical, because one, as a member of the internal committee, one needs to be 100% sure as to A, having followed the process all the way through, and B, ensuring that everything is recorded appropriately in a well-reasoned written order. And that's really what is expected from every internal committee that is hearing cases. This is required because, as you all know, all committees have powers of a civil court, right? Therefore, with great power, as they say, to use a cliche, comes great responsibility, right? And therefore, there is a responsibility on the internal committee to ensure that the orders are well written and keeping in line with the expectations or requirements that the higher judiciary will have, and of course the civil procedure and other laws require or mandate every judicial or quasi-judicial body to follow, right? So let's jump right into our session. This is going to be a relatively short one, but I'm happy to take all questions at the end of the session, right? Okay. So Now, what is the significance? As I just mentioned, very often findings or reports, findings submitted by the internal committee to management, and if either of the parties decides to go on appeal, then those findings often end up before a higher court or an appellate court because of the manner in which either party may have decided to go in for a sort of appeal, and they're not satisfied with the order of the IC or what have you. So whatever may be the circumstances, very often now orders of the IC end up being challenged in a higher court, right? And very often higher courts are finding that the manner in which the order has been written is not consistent with and is not appropriately written. So very often higher courts tend to send the matter back to the internal committee. They will send the matter back and ask the committee to re-examine. Sometimes if the order is poorly written, they will reject it, and they will say that the IC has not considered all the evidence that has been made available to it. Sometimes, what does that mean? That means that if certain types of evidence has been made available and the IC in its written order actually has not alluded to it, referred to it, etc., then in those situations also the order can be rejected by a higher court, right? Now, in the event there are several allegations, in those instances as well, right? It is if the IC has only arrived at one particular aspect or referred to only one particular aspect of the allegations, maybe there are 4 or 3 or 5 allegations, but the IC has arrived at a finding with respect to only one and has completely not ignored the others, then that's also a problem. So courts require that all the allegations that are brought in front of the IC, they must be appropriately dealt with, and a reasoned finding, either that they are in agreement with the complaint or the complainant, or they are in agreement with what the respondent has said. Either way, every allegation must be dealt with, and that's really the bottom line of what really the higher courts have been saying. So the only way to really counter all of this is that one needs to, the internal committee needs to give a reasoned order, right? It has to consider the evidence, and if it has considered all the evidence, make a reference to the fact that it has considered all the evidence, and make a note of it or make a mention of it in the order. Likewise, if there are multiple allegations, then the IC must, in a clearly written, reasoned order, explain why each allegation must be dealt with, and the IC needs to explain in its order as to why it has either held for the complainant or held for the respondent. So that's part of being on the committee, and those are the responsibilities that come with being a member of the internal committee, right? So the other aspect that committee members need to bear in mind is, and it comes really out of a very, very well-known case, Balraj Taneja versus Sunil Madan. This is a Supreme Court case, and this really kind of, while it is targeted at really the civil courts in our country, this holds true for any other court, any court or a quasi-judicial body or authority that is functioning as such, right? So in this particular case, what the Supreme Court has said is that it's not enough for a judge to merely say that, oh, the suit is dismissed, I have no further, and this is the punishment, or this is dismissed, or whatever it is, right? It's not sufficient to say that. The entire basis of our judicial philosophy is that there has to be a reasoning that is laid down in its order, right? So the whole concept of reasoned order in writing has to be adhered to by every single court in our country, right? So therefore, according to the Supreme Court, every judgment must contain a concise statement of case, right? Just a brief summary of facts, the points for determination in that particular case, right? Which is basically, if in cases of sexual harassment, then the points of determination will be the allegations that are made by the complainant, right? Thereafter, the decision of the, in our case, it will be the decision of the internal committee, and finally, the reason for the decision, right? This is very, very important. One cannot just say that this is my decision and that's the end of it. They also have to give an explanation, and IC has to give an explanation as to why it has arrived at that particular decision, right? So that's basically, in a nutshell, what the Supreme Court really sort of concluded in Balraj Taneja, which is sort of a landmark judgment in this case. If you all get some time, do check this out. This is a very, very important landmark case for those of you who are members of an internal committee. This will the longer judgment will give you a little more insight into how orders should be written. And essentially, what essentially, if we were to sum up this particular issue, it is this: either the complainant or the respondent, after reviewing the judgment, must be able to understand, the facts, circumstances on the basis of which the court has proceeded, and the reasoning under which the order was passed, right? So essentially what we're trying to say is that, long story short, what the Supreme Court is saying is that whatever you do, make sure that the two parties understand the process that you've followed, and you've set down the facts in brief, and basically, finally, most importantly, whatever be your decision, provide a reasoned give a reasoning as to why you passed that particular order. So I see a question as to what the name of the case is. It is Balraj Taneja versus Sunil Madan. It's on the slide, if you can see the slide. Do Google it. You can find it. So that's a little bit about that famous case. So what we have done for all of you here is this: we have put together a small set of a structure of the order, right? On the basis of both the Balraj Taneja case and a whole host of other cases that the Supreme Court and higher courts have passed over the years. We have put together a couple of slides which really gives you how the order should be structured, right? So this is basically, we have tried to break it down into simple parts for you, so that if and when you are in a situation where you're hearing a case, and ultimately as a member of the IC you need to pass an order, this is the sort of like a template or a format that you can follow. Of course, you're welcome to make variations as and when depending on the facts of the case. This is not a sort of a hard and fast template. This is merely something to give you a broad structure that you may find useful while drafting the order. Remember, these are some of the main aspects of the order, or what needs to go into an order, are in the next 2 or 3 slides that you will see, right? Okay, so the first things first, you should start the order by providing brief details of the allegation, which is basically a couple of points. Summarize the nature of the allegation. What is the nature of the allegation? What does the complainant, what is the harm that was done to the complainant? And therefore, what is the claim that the complainant is making, and what is the response of the respondent, right? So basically, let's say if you can summarize this in about 3 or 4 lines or a para, that would be fantastic, depending on the the number of allegations and the seriousness of the matter, or the depth into which one needs to go. And so we've given you a small example, right? In this hypothetical case, the complainant has alleged that the respondent continuously makes sexually colored jokes and remarks to her, both in person and through text messages sent to her. The respondent has denied the allegations of the complainant in full. So essentially, as you can see, this is just a crisp, short summary of a case in which the IC has summed up what is the complainant's main grievance, and what is the respondent or what is the respondent's response, if you will, right? Thereafter, a brief detail of the submissions with reference to evidence submitted. Now, this is again something where now, after step 1, where you put brief details of the allegations, we are going to go into a little more depth as to what each party's submissions are, right? So let's take the same example. Continuing with the same example, you can see The complainant has submitted that the conduct of the respondent has the result of making her uncomfortable at the workplace and adversely affects her efficiency at work, right? So this is sort of the what the complainant is saying. The complainant has submitted to this IC transcripts of the text messages sent by the respondent to her both during and after office hours, right? So this is basically the sort of the very brief details of the submission of the complainant. Now, moving down, the respondent has submitted that the remarks were made and the text messages were sent in good humor and were not intended to harass the complainant or make her uncomfortable. The respondent, of course, has not submitted any evidence or witnesses before this IC. So as you can see, what we have done in part 2 is we have dived a little deeper. We have gone into the submissions, and what the IC has done is it has, because of course this case, what we have taken, this hypothetical case that we have taken is a very simple one. Now, depending on how complex the matter is, the structure of the order will naturally change and you'll have to go into a little more detail. But in this, you can see the first part sort of deals with the complainant, her submission and the kind of evidence she has submitted. The second part deals with the respondent's response and the evidence that he has submitted. In this case, he's not submitted any, and therefore, so that is the sort of brief details of the submissions with respect to evidence submitted, right? So I hope you're all with me so far. Then we move to sort of the findings, right? Here, what we do is we record the findings with respect to the allegation after taking into account the evidence presented. So what is this? At this point of time, what we are doing is, by this time, the IC has obviously already completed its entire investigation. Now, once the IC completes the investigation, it will have certain findings, right? So at this point of time, the IC needs to bring out those findings. So continuing with the example, after examining the complainant and the respondent in person, and after review of the evidence in the form of transcript of text messages that has been made available by the complainant, this IC finds the matter in favor of the complainant as an offense of sexual harassment has been made out against the respondent, right? So if you can see here, the IC has basically summed up that it summed up its findings, which is basically after examining the entire process, they've looked at the evidence, they've spoken to the complainant, they've spoken to the respondent, and they've reviewed the evidence, which is in the form of text messages, right? They have concluded that an offense of sexual harassment has been made out. So that's part 3. That's where you bring out the findings. Now here, part 4 is critical. You now need to kind of give a more reasoned order, right? This is where the reasoning comes in, which is basically the reasons for the findings. Here, the IC has to give the reasoning and then connect the law to the facts, the evidence, and then provide a little more detail as to why it arrived at this particular finding, right? So let's take a look at this in this hypothetical scenario, how that plays out. This IC has examined in detail the contents of the text messages that have been made available to it and find the references contained therein. And at this point of time, it would be helpful if the IC inserted specific portions of the text message that they found to be objectionable, right? So whether it's in this case, it was text message, in any other case, depending on the kind of evidence that you have to insert that specific bit there. And so that's basically what you're explaining to whoever is reading the order, that this is what we found objectionable, right? This IC is of the view that the same constitutes unwelcome behavior of a sexual nature that is covered in section 2N3 of the Act, as well as dash, which is you have to reference the relevant provision of the PoSH policy issued by the company. So note here that it is important that the company says that the IC says that we find this to be objectionable and consider it to be sexual harassment in accordance with XYZ provision section 2N of the Act, as well as XYZ provision of your own company policy. These 2 points have to be clearly brought out in this first part of the order. Moving on. The respondent has not denied sending the text messages in question or making the statements as alleged by the complainant. The respondent's argument that his conduct was in good humor is not acceptable to the IC given the contents of the text messages that has been sent by the respondent to the complaint. While arriving at this conclusion, the IC has taken into consideration the impact of the respondent's conduct on the complainant, thereby creating a hostile work environment, right? So in this case, again, like I said, because it's a simpler hypothetical scenario, the respondent hasn't really put up much of a fight in terms of providing evidence, witnesses, etc. But in the event the case is a little more complicated, right? You will then need to ensure that you actually also sum up succinctly and crisply the respondent's position in terms of whether they had provided any evidence, any witnesses, and why you are giving that weightage or disregarding it, as the case may be, right? Remember, the crux of order writing is to provide a reasoned order, right? So at all points of time, if you're holding for the complainant, say why. If you're holding for the respondent, say why. In both instances, it is very, very critical that members of the IC provide a reasoned order, right? Now, moving on, we will kind of hit the last section of order writing, which is really, you've done your findings, now you're coming to the recommendation, right? And this is the operative part of an order, especially this is the part really that management needs to act on, right? So this is the operative part of the order. Here, the IC has to set forth the final recommendation to the management or the employer, right? You've provided all the reasons, you've provided the findings, you've provided all the evidence, you've clearly explained why you believe either the respondent is guilty of sexual harassment or not. All of that is done. Now your final recommendation is as follows. Here, you have to basically take into account, these are just some general factors. You don't necessarily need to use all of them, but this is something that you can bear in mind. But take into account the severity of the misconduct, right? How serious was it? What is the nature of the misconduct? And, in terms of intensity or seriousness, how bad is it? Any mitigating circumstances, right? Is there anything that the respondent has done that you can possibly use to say, okay, fine, while the offense is serious, in view of 1 or 2 and 3 circumstances or acts that were done by the respondent, which turned out to be mitigating circumstances, we are reducing the sort of punishment or the penalty, right? The last aspect to consider is whether the contravention was deliberate or willful, etc. At some level, that also makes a difference ultimately to the punishment that you as the ICs are going to hand out to the respondent in the event you're finding the respondent guilty. So let's have a look at the hypothetical example. Given the facts of this case and the findings that have been arrived at by this IC recommends that a written warning be issued to the respondent, directing him to refrain from indulging in conduct of this nature, right? So the sort of the punishment, the fundamental punishment that is being given is basically a written warning, asking the respondent to refrain or restrain himself from indulging in this kind of behavior. Thereafter, the IC is also provided financial compensation or penalty as well. The IC also recommends that the respondent should pay rupees 10,000 per month for 3 months, commencing from January 1, 2018 to the complainant as compensation for such misconduct, right? So that's basically the entire kind of how the IC has to write the order. Now, if required, in conclusion, you can add the following: where the complaint contains more than one allegation, and this is really the most critical part of order writing for every member of the IC. Where the complaint contains more than one allegation, the aforesaid pattern shall be followed for each of the allegations. Which means, if you're writing an order and you believe that this is an order that will withstand higher judicial scrutiny, you need to follow the above approach for every single allegation. which is to basically say that the nature of the allegation, what has the complainant said, what has the respondent said, what is the kind of evidence that has been shared, all of those things, and then you provide your findings at the end of it, along with so the recommendation is something that is the final piece that takes into account all the allegations. But steps 1 to 4, as you may have seen from before, you'll have to repeat that for every single allegation, and then finally conclude with your recommendation saying that. And also, so the number of allegations makes a big difference, right, to whether what your final recommendation is. If out of 5 allegations, 4 are proved and one's not, it looks like it looks like, depending on the facts of a case, that the punishment might be quite severe. Whereas on the other hand, if there are maybe 5 allegations, but only one's proven and the other 4 are not, maybe the punishment is not going to be that severe, right? So that's really that's really sort of the kind of the nature of how this order has to be written, the structure of how the order has to be written, in such an event, the IC may sort of consider incorporating a conclusion in the report of the findings, stating its finding with respect to each of the allegations, right? So basically a conclusion which will really give you, in brief, what kind of sum up the entire process, and just sort of something as a sign off of the IC saying that hence this is how we have concluded, or what have you, and so that sort of brings an end to really the entire order writing process. So again, I know I'm going to sound repetitive at this point in time, but what's really of critical importance is to ensure that you're giving a reasoned order, right? Remember, above all times, you need to ensure that you are justifying your order, you are giving logical explanations for your order, and of course, you're giving an explanation with respect to what is the punishment you've given and why have you given that punishment, right? So that's really where we are at this point in time. Happy to take questions now. This is really the entire framework of the order writing process.